Folks, welcome to the next webinar of PI Mumbai. Today we have a very interesting session. We have a senior advocate and lawyer, Aaron Schildhaus, and our own charter member, Vishal Gandhi, who will be taking you all through a very interesting session. It's about avoiding key legal mistakes, especially when you're doing business in the US. Vishal will be actually giving and setting the context to this session even more. And Vishal, if you can take it further from here and introduce Aaron and also set the context for the day, that would be really helpful.
Sure. Thank you. Thank you, Naveen. And I'd like to thank Shabnam and Rob also for all their help in putting this program up together. Good evening, everyone. Whoever's in India and other parts of the world, good morning, good afternoon. I'll set the context of the program and then I'll introduce Aaron. So the idea of this program is to highlight the key legal mistakes that you should avoid while you do business in the US or you invest in the US. It could be as simple as setting up a subsidiary, doing a joint venture. It could be as simple as providing services or products in the US. Anything that you're, business related in the US, what are the key legal mistakes? Now, naturally, with TIE being such a robust platform and you all have all attended multiple webinars. So we're not talking about the basics here. For example, you should have a founder's agreement or you should protect your intellectual property. I'm assuming all of you pretty much know that those are things to do. But these are some of the very high level issues which probably we won't be aware of that Aaron is going to highlight so that we understand the complexity and the likely exposure. And we don't want to sort of, trip ourselves while we're in the US. That's the context of the program. Now, let me introduce Aaron. He is a principal of Martorello, Schildhaus, LLC, which is an international law firm which specializes in representation of non-US entities with their operations and transactions with the US and internationally. Aaron has worked exclusively with executive management and corporate legal departments since decades. And not only does he assist with setting up of new businesses and negotiation of contracts, but most importantly, he helps with compliance with federal, state, and local laws. He helps clients expand business operations, whether standalone or as joint ventures, or in the context of a merger or acquisition. He also, very interestingly, helps evaluate political risks and legal risks and reviews corporate compliance policies, programs, and training. Aaron provides inbound transactional assistance to non-US companies seeking to make acquisitions, as I earlier said, and also assists with selecting the appropriate investment vehicles, complying with various laws such as the CFIUS, FIRPTA, and FIRRMA. He has a very distinguished career and background. He was the past chair of the section of the international law of the American Bar Association, which is one of the world's leading associations in the legal fraternity, and he chaired that in the year 2008 and 9. And with that very brief introduction, I would like to hand it over to Aaron. Aaron, welcome. And I think the Thai audience is eagerly awaiting to listen to your views.
Well, thank you. I hope I don't disappoint. And I'd like to welcome everybody. India is one of my favorite countries in the world. I'd love to be there. In fact, I believe, Vishal, we met the first time when I led a delegation to India about 10 years ago. So it was right after the attacks. And, it was a very difficult time in India. But I think things have come a long way since then. I know there's still strife in the streets of India, but we have our own problems here in the US, as many of you know. So, but the important thing is that the relationship between India and the United States is strong and hopefully growing stronger every day. And what I'd like to do is put up my PowerPoint presentation on the screen, if that's okay. And then we'll go along together with the presentation. And if there are any questions, of course, you can address them to Vishal and we'll discuss them later. So first, let me make sure that I can get this to work. Do we have the opening screen up?
Yes.
Okay, very good. already. Um, this is a particularly interesting time for India, for Indian companies. Um, as many of you know, a lot of the work, a lot of the outsourcing, a lot of the production in the past decade has been coming from China, and there's been a lot of relationships between the United States and China. But in recent years, India has come on very strong, and because of what we share in terms of our values, our culture, our democracy, and our business ethic, India is really poised, I think, to be the go-to place. In addition to that, there are a lot of issues right now and uncertainties concerning China and where the United States relationship with China is. So we're in a particular, there's a particular window of opportunity, and particularly in the manufacturing and technology sectors. In fact, I know of many large US companies who are now increasing their focus on India, some of them as much as 10 times of an increase in investment in India and with Indian companies. So as I say in my slide, carpe diem, this is the good time to seize the moment. And there are plenty of ways to approach the market, whether you do it by joint venture, whether you set up a subsidiary. There are numerous ways, and maybe just initially just by selling into the market. And I should also point out that the Indian talent and Indian executive skills are very well recognized in the United States. Many Fortune 500 companies have Indian entrepreneurs, Indian people at their head, and many of the venture capital companies in Silicon Valley are led by people of Indian background. So it's not like it's totally new. There's the language that we share, there's the common law that we share, there's in many ways the business culture that we share. However, there are differences in the way that people in India approach business and the way business is approached in the United States. And those are some of the areas I want to touch on today. What I've done is listed below under the rubric dealing with the US and in the US, mistakes in various areas. So the first area, general area of division I'm saying is acquisitions, investments, raising capital. And then we'll move to some of the issues and mistakes involved in establishing operations and entities in the United States. We'll touch also on contractual considerations, on intellectual property issues, and then on the hot button issues, which today really are privacy, cybersecurity, and then other issues which may be dealt with differently in India than they are in the United States, but just to give you a flavor of what you should be looking for. The US is very highly regulated in many ways, but with respect to the business perspective, I would say it's one of the easiest countries to do business in. So what I will do is move to the next slide. And but I want to give you a sort of a heads up, starting with acquisitions. Now I realize that many of the companies that are represented today in this program may not be looking to make acquisitions, but it's important to know what the mindset is with respect to criminal violations in the US. For example, the Foreign Corrupt Practices Act has been around since 1977 in the United States, and now anti-corruption is kind of the key word throughout the world. But the FCPA, as we call it, Foreign Corrupt Practices Act, is indicative, if you will, of the approach taken by the Department of Justice and the SEC. The Department of Justice deals with corruption issues, and the SEC deals with stock and accounting issues. There are the treatment of this, I'm using it as an emblem, if you will, for other kinds of criminal actions that can be taken under US law by the Justice Department or by other agencies of the United States government. For example, the FCPA has in the past, in 2020, for example, the total value of penalties that were assessed against companies by the US government was $2.8 billion. And in cooperation with other enforcement agencies throughout the world, the total was 6.4 billion. Now, these are numbers that you may already know. What you may not know is that an acquisition that you make could subject you to successor liability. We have cases, some of them go back a dozen years, where companies have come in, made an acquisition in the US, and then in the course of the acquisition, doing the due diligence, or even after the acquisition was completed, it was discovered that some corrupt payments had been made. In other words, there were some criminal violations of US law. And so you would think that, well, it was, we're a successor, we've got plenty of contractual protections, we're okay, there's nothing to worry about. Wrong. Time after time, the Department of Justice, with respect to criminal cases, has found that if there was a pre-existing violation, if there was some conduct that was criminal in the past, it is still something that can be pursued against the successor company. Now, you would think also that you could make an asset purchase and dispense with the continuation, that you're not stepping into the same shoes, the same shares, if you will. But even an asset purchase could have that effect. Why? Because the Justice Department is going to look not only at the act that occurred, but at who was involved in it. So a successor company may have hired some of the same people, or it may in fact have discovered the wrongdoing and not followed up with it. So if there is a discovery of a wrongdoing, it has to be communicated immediately to the Justice Department, and you have to work together with the Justice Department. There are corporate enforcement policy guidelines enacted in 2018, and they do give some protection. However, keep in mind that even if you do the best due diligence, you may not discover this in time, but if you do discover it at any point that you do make a discovery that there's been some wrongdoing, you have to immediately start working with the Justice Department in order to get all the facts, get them out on the table, and show that you're engaged in putting together a very robust compliance program. Moreover, if there were benefits that went to the company, that inured to the company, those benefits have to be disgorged. So this is something that frequently shocks people when they say, we did an asset purchase, we didn't know about this. Justice Department is going to say, did you? Or did you not? And they're going to dig. They're going to dig to find out as to whether or not there was some indication at some point. But if you show complete openness and willingness to work, and you put in place a compliance program that's very effective, under these new guidelines, the likelihood is that you won't have any problems. Let's move on to another area which is delicate and which is very emerging at this point. CFIUS is the Committee on Foreign Investment in the United States. In 2018, the government passed a law called the Foreign Investment Risk Review Modernization Act of 2018. We we abbreviate it and call it FIRRMA. What it did beforehand, there was a need to report on, provide notice to the Committee on Foreign Investment, to CFIUS, by companies coming into the United States. It was just merely a reporting act. But now under FIRRMA, and as the concern about terrorism and cyber attacks and so on has increased globally, there's been more and more activity in this area. A recent case, a company was fined over $1 million. They didn't disclose, as part of the thing is they don't disclose the name of the companies, but they have announced that the fine was assessed for not complying properly with the notice. So that means that there's increased scrutiny. What does the FIRRMA cover? It really covers perceived security risks. So anytime that you have an investment in US businesses that have critical technologies or infrastructure, or if they have emerging and foundational technologies which are used in computer storage, semiconductor industry, and the telecommunications equipment sectors, it comes within the purview of CFIUS. Now, one of the new areas that were added by FIRRMA was the requirement to provide notice if they're going to be using sensitive personal data of U.S. citizens. And we'll talk a little bit about that in a while when we talk about the data protection and privacy provisions of various laws. But it's important to note that, that this is a new category, and the final category of real note, and it's a fairly complicated law, is where a foreign government has a substantial interest in the acquirer. So you're making an acquisition and an investment in the United States, you must provide this notice and this report on forms that are provided to you by CFIUS. Interestingly enough, three countries which have a lot of trade, particularly Canada and the UK, but also Australia, are accepted from the requirement of this 49% interest. I would say that this is an area that you should be sensitive to, depending on where you are. If you're making an acquisition of real estate, the question is, where is it going to be? How close will it be to strategic areas of importance, ports, nuclear energy, any kind of energy facility, military bases, or other secure or sensitive areas. So keep that in mind as a possible. Not doing it is a big mistake, because if you don't do it, you may find yourself getting penalized. And now the trend is going to be, as I said, more scrutiny and increased penalties. And to the extent it's also possible that the Justice Department might be brought in. There are a number of other compliance areas that you should be aware of, areas where you don't want to make a mistake. I've listed them here. OFAC, that's the Office of Foreign Assets Control. It's a division of the United States Treasury Department. It's based on Know Your Customer, KYC. And it affects all U.S. persons. All U.S. persons are all U.S. companies and U.S. individuals. It's a criminal violation to do business with anyone on the OFAC lists. Normally, they were aiming at anti-terrorism and money laundering, and they're particularly focused on the countries which are under sanction: Iran, Cuba, et cetera, et cetera. So you need to be aware of that. In 2020, $1.3 billion in fines were assessed against companies that had violations of various types with OFAC. And also, once you've had a violation with OFAC, it gets more and more difficult to do business globally because you're kind of under the scrutiny of the feds. I listed the FDA as an example. Of course, the technology companies, or those of you who are in technology companies, probably have no input or interaction in the food and drug area, but the FDA is a very powerful organization in the United States. It covers pharmaceuticals, cosmetics, food products preparation, any alteration, additives. There's a separate area for medical devices. It's complex, and depending on the sector, if you're in any of those sectors, you need to be very mindful that you don't run afoul of the requirements. Not only are there fines, and I've listed the area of fines per occurrence, and keep in mind the fines that are assessed, it's per occurrence. So somebody that does makes a mistake and repeats it, each repeat is considered a separate occurrence. It can get very, very costly. And once again, if there's an egregious case, imprisonment is there. There are other remedies, of course, available in the FDA. They can force people to take things off the shelves. They can confiscate, and they can require compensation. So that's for the FDA area. I listed the Department of Labor, DOL is Department of Labor, EEOC is the Equal Employment Opportunity Commission, and Homeland Security, which Homeland Security is the overarching administration that takes care of the immigration laws. And those of you who are going to be operating in the US, or those of you who wish to send your own Indian citizens, people who are experienced in the business, have to be aware of what the immigration limitations may be. Department of Labor, of course, covers a wide area of requirements, including minimum wage and so on. But discrimination and sexual harassment are usually covered under the Equal Employment Opportunity Commission. Complaints can be costly, they can be disruptive, and they're not necessarily appreciated by companies from outside the U.S. until they get in. But when I was practicing in Paris, in France, and the first sexual harassment case I saw was in the 80s, and it was a big French company that had an operation in the United States. They sent one of their employees over to help train people, and the person was French and had a very French sense of humor, but the sense of humor was misinterpreted, and the person was expelled from the United States on a charge of sexual harassment. So we want to be careful with that. The Anti-Money Laundering Act of 2020 contained within it a Corporate Transparency Act. Now, the Corporate Transparency Act is once again another law which we're awaiting regulations for, but it's going to be administered by the Financial Crimes Enforcement Network of the Treasury. And what they're looking for in this law is a description of the beneficial interest of the people who are behind the companies. So there's been too much concern that there's been too much obfuscation of the people and the controlling entities behind investors, behind operations in the U.S. So this is another area of something to be concerned about. The Federal Trade Commission is a wide-reaching organization, and it provides a lot of good information to businesses, but it's oriented at avoiding and eliminating price fixing, monopolistic conduct, false advertising, unfair competition. And what I did was just set up sort of a penalty page, just to give you an idea. Last year, what was it, 2019 now, Facebook was penalized $5 billion for violating a privacy order issued in 2012. And new restrictions were imposed on their business operations. There was a $170 million penalty against YouTube and Google for violations of COPPA, the Children's Online Privacy Protection Act. So another penalty I listed was the Equifax data security settlement of $700 million. The FTC arranged a settlement in cooperation with 50 states and territories of the U.S. and the Consumer Financial Protection Bureau. Let me go back here. The EU-US Privacy Shield framework, there are 13 cases against companies that allegedly made false promises related to the Privacy Shield. So you can see that the Federal Trade Commission has overarching influence in a lot of areas, which would conceivably touch on many of the areas that you need to be aware of when you're doing business in the United States. And it's a mistake to disregard any of these and not to deal with them as quickly as possible, as quickly as you have any indication that you're in any potential violation. Vishal, you and I discussed this, and it is kind of basic. If you're going into the U.S., we're talking about establishment issues. You really do need to pick the right U.S. entity, the right U.S. vehicle. Normally, if you're going to be doing operations in the U.S., you're going to be choosing a C corporation, which is the normal regular corporation, or an LLC, limited liability corporation company. You must know that these are entities which are formed and determined state by state. So there's no such thing as a federal C corporation. There's no such thing as a federal LLC. It depends on the state in which you're going to be doing business. There are other vehicles that are used, but particularly in joint ventures, you tend to use some of the limited partnership or limited liability partnership, and sometimes in combination with C corporations, LLCs, or maybe a mix. Each scenario has to be examined in terms of what your intention is, what your market is, how you're approaching it, whether you're talking to potential joint venture partners, whether you're trying to go in on your own and eventually raise capital, or even a combination of that. I'll give you just one it's kind of a silly example from my perspective, but a company formed a C corporation because they had been told that an S corporation, they would get pass-through tax treatment. In other words, the corporation would not be taxed. There wouldn't be double taxation. Because when you form a C corporation, the corporation pays taxes, albeit at a lower rate. But when it issues dividends, the recipients pay taxes on the dividends as well. So to avoid the double taxation, people generally set up LLCs or subchapter S. But subchapter S is a special animal in the U.S. It really you're called a corporation, and it's a pass-through entity. Unfortunately, all the shareholders must be U.S. taxpayers, and the company that formed the C corporation, thinking it could be qualified as a subchapter S, was disqualified, and it turned out to be a very expensive lesson. So be careful at the outset. Other entity-related mistakes. Most people think of Delaware or Nevada or Wyoming as the states of choice. And while they're very predictable, and particularly Delaware, very predictable, very stable, with a very good case law, very well developed, the facts may not really dictate that that's the best choice. Because wherever you set up your basic corporation, if you're doing business in another state, you still have to qualify to do business. So if you're a startup entity, it means more paperwork, more concerns, and more fees to pay, more lawyers' fees to pay as well. You certainly don't want to set up a branch because liability flows to the parent. But therefore, I would say that C corporation and the LLC are the way to go. And it's important when you're setting these up and when you're creating your documentation that you have full business information that you share with whomever it is that's doing the setup, whoever your lawyer is that's helping you set this up, because there may be some elements that you can be advised on, such as some of the ones that we're covering today. I mean, you really need to know about it, and you need to provide for it in your operational documents. Obviously, if you're starting an operation, if you don't verify independently that there's no infringement of trademarks or other IP rights, you could be facing some difficulties. Another issue is not filing for the employer identification number. That's the number that is assigned for tax-paying purposes for a U.S. entity. If you establish a U.S. entity, if it's a corporation, it's the Articles of Incorporation. If it's an LLC, it's the Articles of Organization. You really need, as soon as you get those articles approved by the state, which is a very fast process, you need to make application to get the EIN. And in some cases it's easy, but in some cases, in most cases, if you don't have, if you're not a U.S. taxpayer already, you're facing a lot of delays, particularly due to COVID. Things which used to be able to be done within 2 weeks by having a designee now are taking as many as 95 business days. And if you don't have an EIN, you can't open a bank account and you can't file your tax return. So if you're doing business, making money, subjecting yourself to the possibility of income tax, but you're not filing a tax return, then you're in a criminal violation vis-a-vis the Internal Revenue Code. And that's something you don't want. I said also here, not specifying governing law. That really would be with respect to a contract. It's important to specify the law that's going to govern the relationship that you have with a joint venture party or with any other party, or even within a sales situation. So keep in mind that regardless of what kind of dispute resolution you choose to follow in the event of a dispute, your agreements really need to specify a governing law. The intellectual property rights is critical, of course, for any company. And I've cited a couple of cases here just to show you that really a careful structuring of your agreement, even in terms of if you have a work for hire agreement or you have an employment agreement, you want to be very very clear that you do two things. You specify the governing law, and that you specify exactly that normally that you have the right to the copyrights that are developed by the person who's in your employ. In bilateral agreements, in joint ventures, where there are licensing provisions, you need to describe very carefully, exactly what's being licensed, what's being given, and you need to have provisions for termination. You don't want to have somebody using rights with a claim that they have the ability to use them after you've terminated the relationship. For patents, you have to file to get protection. For trademarks, it's advisable, and for trade secrets, it's protected by contract. Copyrights, it's optional, but you get more protection when you file. Copyright filing, something that's very simple and very inexpensive. Trademark filing, it's really advisable because it provides you with more protections in the event that somebody, in the event that you have a claim against somebody. I said in this particular slide, these are mistakes in raising capital. If you don't comply with Securities and Exchange Commission requirements, if you're trying to raise money, for example, or if you're set up in a situation where you're going to be selling stock in your company, you may be dealing with a listed company. You may want to get a listing. Some of you may be listed already, I don't know. But if you're going out and to get capital, you still need to be compliant with state blue sky laws as well as SEC laws. So it's important to examine the capitalization of your company, the structure, what your anticipated earnings are, and how you're going to distribute them, et cetera. If you're trying to raise capital, if you're issuing a private placement memorandum, for example, which you would do in compliance with Regulation A of the Securities and Exchange Commission, you have limits as to the number of sophisticated investors, and there are different types of Reg A forms that need to be filled out. So you just need to be aware of that from the beginning. You can't just go land in the market and think that you can start selling shares. It's important to be very cognizant of what the limitations are and what the compliance requirements are. Once again, if you're setting up an entity in the US, you certainly don't want to be thinly capitalized, because if you are thinly capitalized and the corporate veil is pierced, there's personal liability, and the liability would go back, through the entity that you established to the parent entity. So I always like to advise my clients that they should take into account, a realistic assessment of what kind of cost it's going to be to set up, and to have a good budget and a good business plan. This is obviously a sine qua non, something that all of you know, but for purposes of those who may not be familiar with it, keep in mind, it's easy to set up an entity in the US, but it's also important that it be adequately capitalized, and that your ongoing and initial expenses are well thought out and well provided for, and you know how you're going to be paying for them. Transfer pricing is something that's done worldwide. It must be arm's length. It must be documentation. Those of you who are transferring equipment, for example, or inventory from a parent to a subsidiary or within a group, need to be aware of the transfer pricing requirements, and need to be sure that you've well documented the fact that the transactions are, at market value and at arm's length. additional mistakes in contracts and regulatory area would be to have non-compete provisions, which are normal and understandable, but they need to be clear. They need to specify the duration. They need to specify the precise territory. They need to be reasonable. And these are the types of non-competes can be in a business-to-business contract, can be set up as within the joint venture agreement, and frequently you find these at the employment contracts. You just need to be sure that they're well thought through. Liquidated damages are often a provision in U.S. agreements. They can't be penalized. They can't be penalties or construed as penalties. I think you have something similar in India, but it can or cannot be advisable. My sense is that if they're reasonable and you can show that they're reasonable, it helps to have them in the contract. You need to have clauses that limit the liability. There are indemnification clauses, which are classical. I'm sure you're all familiar with them. Sexual harassment we touched upon earlier. It's something that companies operating in the U.S. need to be aware of, as they need to be aware of all the labor laws and all the equal treatment under the laws for all people who are employed. And then the last element here is privacy and cybersecurity protection damages. Normally, there's some federal oversight, as we saw from the Facebook case, but principally the privacy laws tend to be state by state. And, whoops, wrong slide. So, because I'm coming to the end here, there are states, for example, that are in the forefront. As all of you are aware, I'm sure, Europe took a major step forward in the whole area of privacy and in terms of data protection for individuals by enacting the GDPR, the General Data Protection Regulation, which is now ironclad law in Europe and is being pursued, and it has international application. California enacted its own law in this area, and it was very much modeled on the European law, and that's the CCPA, the California Consumer Privacy Act. The state of Illinois has a law which is also being copied, called the Biometrics Information Privacy Act. You need to be aware of these because if you're operating in the U.S., chances are you view the U.S. as a whole market. It's true that there's 50 states within the U.S., and each state has its own. Some may not even have, at this point, privacy laws. But if you're selling in one place in the U.S., you're probably at some point going to find customers, and very quickly, or potential customers that you're reaching out to through your website and through your outreach of other types. They are California, they're subject to California law. You're subject to California law under that situation. And you're subject to Illinois law if they're in Illinois. New York is in the process of copying the Illinois law. And one of the interesting things about the BIPA, Biometric Information Privacy Act, is that it provides for private rights of action. So you'll see more and more class actions being filed in the United States for violation of these types of laws. In many cases, for example, particularly in Europe and in the California case, the state is the main operative party, but where individuals are given the right to bring class actions, it makes it a much higher risk for all of you operating there. So I think with that, I can perhaps ask Vishal if we have any questions, because I think we're at the point where I'm supposed to receive questions. I can't hear you. I'm sorry, I don't hear you.
Sure. Yeah, sorry. I was, yeah. Can you hear me now, Aaron?
Yes, I do.
Right. Well, thank you very much. That was a very, very informative presentation. And, as I mentioned at the beginning of the program, that these are very high level issues and gives a sense of the potential liability for the simple mistakes that one might make, unlike what, we are already aware of, for example, not having founders agreements or not filing for certain basic patents. But what you highlighted was very high level, very useful. We do have a few questions which are actually a few basic questions, but let's answer them because that's what the audience wants to know. So Nilesh has asked a question that I'm an Indian citizen and I would like to become a partner in a LLC where two other members are US citizens. So can I, as an Indian citizen, become a partner in this LLC? And what precautions do I need to take? Because naturally he's in the minority. So that is the question.
Absolutely. There's no restriction on nationality or residence or citizenship. Anybody, any individual can be a member of an LLC or of a corporation. You can be the sole shareholder, the sole party. So, yeah, okay. My screen just shifted. So
Yeah.
the other precautions I think would be really in the nature of a founders agreement or in the contractual terms that you would agree to with the other parties. I think that's really the best way to protect yourself when you're partnering with U.S. entities, U.S. persons. Not only, let me point out that you can own, to be a shareholder, you can. It's not necessary to be an individual. An entity can be a shareholder as well. And if it's a wholly owned, if it's something that you set up by yourself, which is not the case with the question here, if it's something you set up yourself, it could be you would be the responsible party, and you could hold it through another entity, and you could own all the shares in the entity. You don't have to have U.S. shareholders in the entity in order for it to be operable.
Right. Great. So that answers Nilesh's question. Then we have another question from Samir, who says, what is the process to establish a LLC and what is the related cost? So if he wants to set up an LLC, what is the procedure? Is it complicated, simple? How long will it take? And what's the related cost?
It's normally very simple, but if you're not a U.S. taxpayer, the issue of the EIN becomes quite serious. So, but in normal times, in normal non-COVID times, it's fairly rapid. But if you are a U.S. taxpayer already, you can form an LLC very inexpensively, depending on the state, and you can do it in less than a week. It's even possible in some states to do it, within a day or two. But if you're not a U.S. taxpayer, you're going to have to work through a designee. Normally, it's your attorney, and the attorney can advise you in that respect. Depending on the state you choose, the filing fees for an LLC can be as low as $40 to as much as $500 just for the filing fees. Kentucky charges $40, Massachusetts charges $500. If it's a C corporation, it's also a range. It's interesting that the range is actually less. It's from $35 in Florida to approximately $300 in Texas. But you have to look at it carefully because the annual fees vary from state to state. So one where you have a high initial fee, maybe lower in subsequent years, or it may not be. Really, I think determining which state you want to be, which state you're going to be operating in, the normal advice that I like to give clients is, if you're going to be setting up and doing operations in one state, probably makes sense that that's the state where you should establish it.
Right. We have another question from Subha, which is, what is the difference between an S Corp and a C Corp?
Well, I discussed that in my presentation. A C Corp is taxed at the corporate level, and if it issues dividends, when the dividends are distributed, that goes to the personal tax liability of the shareholder. An S corporation is treated as a pass-through entity, so there are no, the S corporation itself pays no taxes. The individual pays taxes on the distributions. And whatever is earned by the S corporation or by an LLC, for that matter, in a given year, is construed as being the taxable income during that year to the recipient of the to the person who was behind the entity.
Right. We have another question which says, if my website is accessible in the US, what laws do I need to comply with?
Well, if it's accessible in the US, I think you basically need to be in compliance with, first of all, the privacy requirements. I would suggest that that you look at the CCPA, the California law, you look at the Illinois law, but you also, you really need to be compliant. I think if you're GDPR compliant, you've gone a long way towards compliance. But if you're not GDPR compliant, if you're really looking just at the US, you really do want to be compliant with the most restrictive states in the United States. And then, of course, all the other things that I mentioned, you certainly don't want to be making any misrepresentations on your website. You don't want to run afoul of any of the constraints that are imposed by various regulatory authorities, notably the FTC. So you need to be conscious of that as well.
Yeah. There's another question that if I'm selling to a US entity, what is the best way to secure my payments?
Well, that's a good question. The best way to confirm is to have them pay you up front before you do anything. Of course, realistically, that's not too easy. But I think a letter of credit is good, and possibly you may want to have some guarantors in the equation. But a letter of credit that's been accepted by your bank is probably the most traditional way that we advise people to protect themselves for non-payment.
There is a couple of other questions. There are some very specific questions which I'll avoid and which I would request the audience to send it to me or to Aaron, and we will try and reply to those. There is another one. Manoj says, if we want to hire an employee as a consultant on contract, does it require any company formation first? I think what he's trying to ask is, because an employee, if they want to hire a consultant, basically, does it require any company formation first? I mean, I don't think you don't need a company formation, but Aaron, you can confirm that.
No, I agree. I mean, if you just want to have an arrangement with somebody who's a consultant and you don't want to form a company, then it's a contract between you and that consultant. If they're using if this consultant is using your intellectual property, you want to be very careful that it's, that the access and the use is controlled. But you don't need a company in order to hire someone. But if you have a company and you want to hire someone, it's a good idea to have them under contract. There's a difference between the characterization of someone as an employee or as a consultant. If they're, so you need to look carefully at the agreement itself. At, what's the intent of the parties? Is it someone that's going to be working on a full-time basis? You can't characterize somebody as a consultant. It was the same situation with the Uber case, which I may have mentioned in my slides, or I may not have actually discussed it. But Uber in California, particularly, was claiming that its drivers were consultants. They were independent contractors, or what we would call consultants. In reality, when you looked at the constraints placed upon them, they were viewed as being employees because of the amount of hours that they worked, because of the possible types of benefits. So you really need to look at each situation separately.
Right. There are quite a few other questions. We have about 2 minutes left, but I'll take a few more. Gopal says, if I'm providing
Through a corporate entity, than it is to be doing it individually, because the lawsuit that ensues, keep in mind that lawsuits in the United States are quick. It's not like in India. I understand that litigation takes a long time, but I wanted to point out early in this program, many of the viewers know it. The United States is quite a litigious society, and the plaintiff's bar is very strong. So it's very easy for someone here to bring a lawsuit. It may not be cheap, but people have a tendency to bring litigation and to bring, at the drop of a stick. So you really want to be protected, and you don't want liability, and you can never tell which way a case is going to go. So, of course, there may be other issues, extraterritoriality, and in terms of service of process, and but those are very legal questions.
Great. I think we've already run over time, so I won't put any more questions to you, Aaron, although we have quite a few interesting questions. I would encourage everybody to reach out to Aaron or to me, and we can definitely help you out with setting up business in the US or investing in the US. But thank you very much, and thank you, Naveen. Really appreciate you and Ty hosting us, and again, to Shabnam and to Rob. And with that, thank you very much for attending. Have a good evening.
Thank you all.
And Vishal, could you kind of just drop your contacts on the chat so that all of us can write to you and Aaron?
Sure.
I'm sorry that I can't stay longer, but
no worries, Aaron. If required, we'll get you back again in about a month or so.
With pleasure. With pleasure. And hopefully there'll be a time when I can travel and be there in person.
We'd love to host you here.
Oh, thank you. It's very kind of you.
We look forward to the time when we could also have a physical meeting set up and members could come up and join us. And I think
That would be
India is
great.
about 3 months away from that. So
Yeah, unfortunately, but let's just hope that the vaccine is made available to everybody all over the world soon, and that this terrible nightmare goes away. But in the meantime, life goes on, business goes on. I'm really delighted with TIE's involvement, and I thank you very much. Nice to meet you as well. So,
likewise.
are people still on the phone?
Yeah,
Yes.
they're
Yeah.
Oh, I didn't realize that. Okay, well, anyway, thank you very much, and thanks to all for participating. Thank you, Vishal, for your.
My pleasure. Thank you.
Thank you.
Thank you, Aaron.
So much. Bye-bye.
Have a good evening. And for the ones who are still available, just a gentle reminder that we have this venture investing masterclass coming up. Please inform your people and let them quickly sign up for this. This is going to be starting next week. We already had a cohort 1 of 45 very interesting potential angel investors today who have already started investing. Sanjay does go through in detail each and every step of investing, and please feel free to join us for this class. If you need any testimonials, please do write to us. We'll be happy to put you in touch with people who went through this session. It was a 16-weekend session, a grilling one, and people loved it because they got live action of pitches, investing, and especially in their own individual thesis development. So very interesting one. Thanks a lot, and we'll see you soon tomorrow. Have a good one. Bye-bye.